This bill seeks to abolish civil commitment. I will say this at the very beginning. There is no code section that I find more offensive and more inconsistent with due process and fairness than this civil commitment. This bill would repeal Virginia Code Section 37.2900 through 37.2921, which provides and allows for the Commonwealth to civilly commit somebody under the Sexually Violent Predator Act. Now, let me tell you exactly what I'm talking about. I'm talking about that individual who has been convicted of a sexually violent act, tried by a jury, sentenced, go through the sentencing proceeding, and is sentenced to 30 years in jail. That person finishes his 30 years in jail, has had no incidents in jail, and then he has a civil commitment hearing. And I'm going to discuss that process in just a moment, and then is essentially reincarcerated at the Virginia Center for Behavioral Rehabilitation. Let me kind of set out a little background so folks know. It was 22 years ago that the Virginia General Assembly created a process for committing inpatient treatment those individuals who had committed a sexually violent act, and the process is administered by the Department of Behavioral Health and Developmental Services, DBHDS, and it's driven by a psychological evaluation. In front of you, what was just passed out was a static 99R tally sheet. I want you to look at that for a moment, and I want you to consider this situation. Somebody has been convicted, and a judge had a sentencing hearing, and at that sentencing hearing, that judge considered everything, including past convictions, and sentenced that person to a significant penitentiary sentence, Mr. Chairman. And then, within 6 months of him being released, this person then is reevaluated. And the first evaluation is this tally sheet. Now, if you look at it, items 3 through 10, or excuse me, 3 through 10 has already been considered by the judge. Past crimes, violent or nonviolent. There's a new one, number 2, ever lived with a lover. I don't know what that has to do with anything. And then the age upon them being released. So this is what it does. It has this form, and then if you have a 1, 2, or 3 rating, you're considered an average risk to reoffend. 1, 2, or 3. It's easy to get to 4 or 5, which is above average risk. And if that occurs, then the process is, after being screened by DOC, then there's a committee formed. And that committee includes DOC, DBHDS, a psychologist or psychiatrist, state paid, and a representative from the Office of the Attorney General. You know what it doesn't include? Any representative for the defendant. So a person goes through 30 years, is ready to go home, has committed no other offenses, and is recommitted because why? There's a circuit court hearing, and there is probable cause to find that the person is a sexually violent predator.
There's persons that are already there in civil commitment. And so my question is, I mean, at best, wouldn't you want to see if this is the right thing to do? Because these are people who have been deemed to be SVPs, and they are.
The only way I can answer that is...
And to let them out would be to put children and women and men and our citizens at risk.
Okay, Senator Morsi, would you like to have
this? Senator, how do you look at that person and they've had a stellar career, or that's a poor choice of word, a stellar period of incarceration, and determine that they will do it again, other than one factor: they've done it before. And I would ask the senator, if somebody had committed 3 murders before, he's locked up for 30 years, and you predict, and it's only probable cause, that he will murder again, just continue the incarceration?
Well, if there's some people here who'd like to speak, let's
Well,
go.
and if I may,
have a
Mr.
few
Chairman, just
people
very
speak,
quickly, and
okay?
I think he brings up a good point, though. But we're talking about a potential mental disorder that some of these that are so sexually violent that they cannot, it's a compulsion that they cannot control. And that prison may give them a structure that prevents that compulsion from being acted upon. But once that they're in the free society, that compulsion overtakes them.
Okay.
Now, Senator Morsi, does the AG support this? Has the AG said this is a good bill, the Attorney
bill,
General's
no.
office?
Oh, no, they're one of the folks that lock them up, keep them going. They're one of the people on the committee, along with DOC and the AG and the psychiatrist paid by the state, that says, we predict
All right,
they will commit the crime again.
Senator
Mr.
Morsi,
Chairman, I know
Thank you,
there's
Mr.
some-
Chairman.
There are people who would like to speak
Yes, sir.
one way or the other. So,
I just want to say, as a child victim of sexual trafficking who was brought to this country at the age of 7.5 and started being raped and abused and traumatized by a parent at the age of 9.5, and who suffered significant trauma throughout her childhood and young adulthood that led her to be incarcerated, I must respond to the senator. There are no pretty prisons. No matter who you see in prison, it's always going to be ugly, and you're always going to be jaded against that person. But I'm saying here today that I have forgiven everyone that has caused me harm, everyone that has hurt me as a child and as a young adult. And I say to you that a lot of those people had trauma themselves, and we never, ever give them the opportunity to address it, to work on it. And that's why we see this continuation of abuse and violence and hurt, because we don't address it. We should invest in that instead.
My name is Dr. Bernita Thompson, and I'm an African-American citizen and homeowner in Hampton, Virginia, with an extensive family in Virginia. I also own and operate 2 schools. The SVP laws have negatively impacted my family personally and a large percentage of other Black families in Virginia. The 2010 census showed just under 20% of Virginians were Black, which still holds true today. Yet over 60% of the men labeled with the scarlet letters SVP are Black. Indefinitely, unconstitutionally restrictions in and out of this shadow prison system that they call VCBR, which is masquerading as a treatment facility after they have already completed their criminal time.
My name is Mr. Huff, a Sergeant Huff, exact Master Sergeant, retired United States Army. I was unfortunate enough to be in BCBR. I had completed my prison sentence, and I was wrongfully convicted to begin with. That was later adjudicated 20 years after spending time in there. I would agree with the young lady who just spoke that this is a shadow prison. There's no therapy there whatsoever. Anybody that would disagree with that, I'd have to argue with. I defended this country, and I love this country. But I am tired of seeing people put away when there's other ways to treat them. Treatment and not prison. I would support this bill.
I'm a law professor in Minnesota, and I've studied this area for about 25 years, written a book published by Cornell University Press about these so-called sexually violent predator laws. I'll just make a couple of really quick points. Number one, these laws have been held to be constitutional by the US Supreme Court on an assumption that they would be very, very narrowly applied. In practice, they're not. There are few limits on their application. Number two, these laws take a mental health model, expand it, and turn our Constitution on its head. Our revolution was fought to put a limit on the possibility of this sort of government power, exactly this, which is locking people up, not in punishment for a crime, but because we're afraid they might do something in the future. In my opinion, it's a very dangerous concept, and it is contrary to our.
If the court believes that they're a danger, then they should be sentenced to a longer sentence. If it's locking somebody up and continuing to lock them up for something that they might do in the future. So we support this bill wholeheartedly. Thank you.
Okay, next.
My perspective, very briefly, and I respect the committee's time. The first I would say is there is civil discovery, appointment of counsel, experts appointed to both sides, a jury trial, and appeals to the Supreme Court. I've been to the facility. I've interviewed clients. They have annual review hearings in front of a court. There's treatment going on. Ultimately, and the thing I want to leave you with, members, is the practical aspect of repealing this thing outright. As of December 31st, my calculation, there are 405 sexually violent predators at VCBR. They're committed there. First of all, they have a predicate of a sexually violent offense, but that's not the standard, not just a sexually violent offense. They have a mental disorder that makes it likely for them to reoffend. And that's, doctors have evaluated that. So we have people who are sick, not just criminals, but people who are sick, and they need treatment. And if this bill passes, those predators who are sick will be released. Half of those individuals would have no probation obligation. And if it's repealed entirely, those who are already on conditional release, and there's 274, 75 of those individuals, no GPS tracking, no longer subject to sexually violent predator treatment, and need sex offender treatment. The overall concern about raising public safety is this. These individuals, most insurance plans do not cover sex offender treatment. And so financial assistance for people who are going to be thrown out with no home, with no tracking, with nowhere to go, individuals who are sick and who have a propensity to reoffend. On a personal matter, I respect and understand what Senator Morrissey is trying to do. I thank you, sir, for trying to reform this. But as a practical public safety matter, we need to be concerned. It's just not prudent to throw these folks out and get rid of this entire model. So I respectfully ask them.
I'm a resident of Prince William County. Some of you might remember me as being the instrumental in the creation of the Civil Commitment of Sexually Violent Predators program that we were discussing today. In 2003, the General Assembly, Governor Warner, Attorney General Kilgore, with the affirmation of
I am a student at American University. I am 21 years old, and I am a victim of sexual violence and harassment. I appreciate what Mr. Andrews is saying here. I understand where he's coming from. I know he's asking you to think about your children. In many cases, the word "I am" still a child considered by the state. I want to speak to you because I'm also a young woman and passionate about justice and advocating for change. I'm here to challenge you that justice isn't just for you, for me, for Mr. Martin. We don't get to pick and choose who deserves dignity or equality. There aren't exceptions to human rights. We shouldn't lock up people for what they might do in the future or who they could potentially be. That is not how our justice system works. When someone has completed their prison sentence, when they have repaid their debt to society, they deserve to go home. What Virginia is doing to these hundreds of men and their families, indefinitely warehousing them in a carceral setting after the completion of their prison sentences, that is not justice.
So you support the
Senate Bill 1244 would end Virginia's failed experiment in this case.
Thank you.
Thank you.
Next.
My name is Megan Ebos. I'm the founder of People for the Enforcement of Rape Laws, an organization founded by and for people who have experienced sexual violence. When I was 16 years old, I was raped by a stranger who had broken into my home. While you might expect someone in my position to support harsher punishment, however, I speak in support of Senate Bill 1244, which would repeal a law that allows the state to commit people convicted of certain sexual crimes to psychiatric facilities after they've completed their sentences. We know that harsher punishment does not make us safer. Fewer than half the states have these laws on the book, yet published research shows that they have no impact on the rates of sexual violence. We know that they do not make us safer, but they do create harm through subjecting individuals to further government control after they've paid their debts to society. Civil commitment for those who have already served their sentences should not be justified in the name of people like myself who have experienced sexual violence. Thank you.
Thank you.
Chair, Jerry Fitz. I'm with the Virginia Department of Corrections, and I'm here for, the Department of Correction has no position, just here for any technical questions that may arise.
Okay, next person.
I'm a clinical psychologist, PhD. I've treated thousands of sex offenders and been involved in hundreds of sexually violent predator cases. My point is that, and I would encourage the committee to consider the fact that SVP commitment laws were passed 30 years ago, but they lack psychiatric acceptance and scientific validation still at this date. The official position of the American Psychiatric Association is that SVP laws undermine the legitimacy of the medical model of commitment. There is no such thing as a mental abnormality in the Diagnostic and Statistical Manual of the American Psychiatric Association, even though the DSM diagnoses are used as proxies for mental abnormalities. And the DSM Diagnostic Manual does not discuss, has never discussed the concept of a mental abnormality. And this is because the Psychiatric Association believes the concept is largely invalid. From a scientific standpoint, the reliability of the diagnoses are inferior, they're negligible. The definitions of the main terms, mental abnormality, volitional emotional impairment, menace to others, are too vague to be used scientifically. And the recidivism rates for SVPs are very low, and particularly for Virginia. I've got data that indicate that the recidivism rates for those who have been released, convicted as SVPs, but then released to the community is on the order of 2%.
Spoffman. I'm Just Future Project, and the two lawyers that spoke, Martin and the other one, are completely, utterly wrong. Okay. There's a 15-year-old who was
point
15.
of order.
He
She's not stating her
charge.
Position, Mr. Chairman.
State your position. Give your name and state your position. What are you for or against?
My position is you all are misrepresenting information and completely inaccurate information.
What position
you're stating it as fast.
What is your position?
I am for SB 1244.
Okay, thank you.
I want you all to.
Yeah, I am for the bill, but I will have to differ with one of the senators that said that people cannot fall through the system. I am the past president of the Richmond NAACP, and I advocated 35 years in prison, med parole, did excellent stuff in the prison that the prison is still using today. Upon his parole, 6 months, as was said, he got a letter for civil commitment. His crime was committed when he was 15 years old. He never made it to the street. So he was civil committed, and then he was individuals that have done their time.
I think this bill ought to go to the Crime Commission, where they can look at it in conjunction with the information coming back from that study that's going on. So I moved to PBI the bill with a letter from you, Mr. Chairman, asking the Crime Commission to look at this.
Is there a second? Any discussion? The motion is to PBI the bill with a letter from the chairman to the Crime Commission to study the bill. All in favor of the motion say aye, or vote aye. I wish we had 10 hours to study this.
I know.
Yeah, I know. Yeah. All right, thank you. Now.
Thank you everyone for watching. I would like to touch on some points displayed in the video. The committed railroaded Morrissey's bill. There were a stunning list of powerful speakers in support of repeal. The senators who spoke against the bill were deceitful. Proponents of Virginia's shadow prison are standing on the wrong side of history. Senators denied the fundamental humanity of the people harmed by these systems and the people who came to testify to this committee. That kind of person shouldn't be making laws for Virginians. Thank you everyone for watching. We hope you can be in support of SB1244, for you will not only be protecting yourself and the people you love, but you will be protecting future generations. Thanks again.